That's a nice thing. Hi there, how are you? Great, how are you? Good. Yes.
Hi, I'm Shivani. I don't know if you remember we met. How are you? I'm good. I was just, I'm here for the coffee time. We're here, so I thought I would.
Yeah, we've met a number of times as well. Yeah, when you were back at ISIL.
Yes.
Or ASIL.
Oh, yeah, no. One of my colleagues is actually at the ASIL conference.
Yeah. Well, I think our talent is to wrap this up by 4 o'clock. So we're doing that across town.
All right.
So.
Oh, that's it. Yeah, I figured. How are you doing? How's it going at ABA?
Yeah.
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 Yeah, because I think you actually were at ABA. I saw you at the World Bank World Law Conference last year. Yeah. Yes. Yeah.
So now I'm fully ensconced in this role.
Well, we're doing a big thing at ABA with the iJump program.
Oh, that's right. Oh, that's right.
Starting now, but
Now the new
is like coming. 18th, on the 18th, yeah. We have it all set up.
I think I'm really excited about the project. It's a model of
Yeah, and we're that. We talked to us about it. We're hoping that we're hoping like after the first years, our program officers help fund and have like
Sorry, I'll
separate
be-
projects. Hopefully that'll be great. But anyway,
I'll proselytize.
yes.
Hi there.
Computer over here.
Good to see you. How are you? Elena, if you're there.
Yeah.
If I can ask everyone to find a seat, we're going to try to start promptly so we can end promptly as well.
What a memory. That, the principle that years ago, and nothing that happens yesterday or 5 minutes ago.
I don't know what I have.
Right, I know, right. How nice. Thanks. Finding. I'm going to have to look up 43 and 44 again.
We're going to build it and they will come. Good afternoon. My name is Elizabeth Andersen and I'm the director of the ABA Rule of Law Initiative. And as Judge McKeon said this morning, we're just really delighted to be a part of this celebration of the War Crimes Research Office and its contributions to international justice and the rule of law for 20 years now. I can't believe it. This final panel has 3 tasks. We're supposed to be practical and offer some practical guidance, try to find some threads of the discussion and do some summing up of our day, and be prompt so that we can all get to the Grotius lecture, which is downtown at the beginning of the ASIL conference starting at 4:30. And given that there are 50 heads of states and their motorcades between us and there, we want to make sure that folks have time to do that. So I'm not going to spend much time introducing our panelists. Their bios are in your books. We've got a great collection of experts. who've been doing a lot of research and thinking and acting in the intersection of international justice and rule of law. They are on my right, Elena Baylis, who's Associate Professor of Law at the University of Pittsburgh, who's done a lot of studying about the people who do international justice, the justice junkies, as she has dubbed them. Next to Elena is Guy Makongo, who's country director. We're happy at ABA Rowley to claim him as one of our own. He's the country director for ABA Rowley in the DRC, where he has, among other things, responsibility for those mobile courts that you've heard talk of. And on my far right, your far left, is Paige Arthur, who's the founder and principal at Public Action Research, an organization that is focused very much on evaluating, developing tools for organizations to evaluate work in this area, and she's been a real leader in thinking about that. We're going to have a pretty free-flowing conversation among us up here, and then hopefully leave time to invite you to be part of it as well. So our topic is practical guidance for constructive engagement between international and domestic justice practitioners. So there's a lot compact in that topic, and I'm going to turn to Elena first and ask her to help us unpack it. How does constructive engagement among those different actors vary depending on whether the actors are operating on the international plane or the national plane or between those two planes? What kinds of mechanisms do we need to facilitate constructive engagement among these different actors?
Thanks, Betsy. And I also want to thank the Washington College of Law and the War Crimes Research Office for putting this really interesting day together. Closer. For putting this interesting day together. I think a lot of great ideas have come out of it, and so hopefully we will pick up on some of those. I've been given the task of disaggregating this question a bit. So when we talk about constructive engagement, I think the first question is what we're engaging about. If we say that our overall purpose is effective domestic trials, what we've been hearing today is that there are a lot of different components that go into having effective domestic trials. And so that's the first thing that I'd like to disaggregate. I think we could probably all agree on 4 components that are required. The first is the institutional capability and functionality of the national justice system. The second is a degree of specific technical expertise in handling these kinds of cases that are based on international criminal law or on domestic rules that relate to international criminal law. So we've heard a bit about how you need special investigative skills, you need to be able to handle victims, and so on. You also need 2 components that are outside the legal system primarily. You need what we've heard called a variety of things today, a sense of social demand for justice, a valuing of the process or grounding in the local justice, in the local social system, a sense of local ownership. So that social relationship between the people in the society and the courts and the trials that they're holding. And then you also need political will, which means, at the most basic level, of course, the government getting out of the way and not creating obstacles and threats to the process, but also participation, so resources, cooperation, engagement. And as I said, I think those 4 components are pretty uncontroversial. We heard a fairly similar list first thing this morning from Anton Steinberg, the speaker from the ICC Office of the Prosecutor. In my view, the difficult questions are not what components do we need, but rather, how do we operationalize each of these components, in particular countries and situations, given the specifics of where that country is on each of these components? So some countries have a lot of capability, but no political will. Some have a lot of social demand, but no technical expertise, and so on. So each country has a different set of circumstances vis-a-vis each of the necessary components. And then the second question is, as you're operationalizing those, what role can internationals usefully play in that process? Given that these are fundamentally domestic processes in domestic institutions that are ultimately controlled by domestic actors. I think the shift from the International Criminal Court, other international tribunals, hybrid tribunals where internationals are either in control of or actively controlling at least parts of the process is huge. So, so those are where I see the challenges. So the second piece that I'd like to disaggregate is who are the involved actors in attempting to operationalize these components. This, I think you could disaggregate fairly far down. So even the big components that I talked about, right, each have all kinds of smaller pieces that we could talk about individually. And everyone here who's worked on rule of law programs has probably worked on some of those small components for years at a time. The same is true of the actors. So, but in broad sweeping form, we have national actors who are actually engaged in courts trying cases, attorneys, the registrar's office, and so on, the judges. Then you have their counterparts at the International Criminal Court and other tribunals, internationals who are also directly engaged in cases. On the other hand, you have people involved in rule of law and development work. You have internationals coming from development agencies in foreign governments, from NGOs, and then you have nationals who are working for rule of law and development. And these groups have varying and conflicting interests in accountability. Some have mandates that relate pretty directly to accountability for atrocities, especially people who work for, say, human rights organizations, of course, the International Center for Transitional Justice, organizations like that that have a direct interest in justice and in transitional justice. But a lot of agencies have a much broader purpose to promote development or perhaps rule of law generally. And so accountability is one piece of what they're doing. And then the last really big catch-all group I'm going to is other power-wielding actors. So here I'm going to throw in members of the national government who aren't directly working on rule of law or on justice matters, militias that are operating within the country, foreign governments operating within the country who have interests in trade and security and other things besides rule of law, civil society actors, anyone else who is wielding some sort of power that affects the process. Each of these groups has different expertise, different purposes, and different interests. For example, domestic attorneys are likely to know their own legal system quite well, but likely not the international criminal system. International attorneys have the opposite situation. People working on rule of law are directly concerned with building national systems, while people engaged in trials are primarily concerned typically with their particular cases. So we have different degrees of expertise vis-a-vis the components that I talked about at the beginning, and different degrees of connection to the purpose or mandate of what each person is trying to accomplish in their own job, in their own institution, and in their own role. So how do these pieces come together? And how can internationals most effectively engage? My main goal here is to disaggregate, but I'm going to offer just a couple of initial ideas on how we can fit the pieces back together before I turn the mic over to someone else. And in doing so, I'm going to focus on one piece of this. So I know that Paige is going to be talking about donors and civil society. So I'm not going to talk about that. That relates, I think, a lot to the social and political components. I'm going to talk mostly about how internationals can effectively engage with national actors on technical and institution building aspects. And in doing that, I'm going to focus even more specifically on the question of how do you effectively engage? So there's a lot out there on what the technical component should be, several people actually who've spoken already at this conference, Jim Stromseth in the last panel, and Eric Witte in one of the earlier panels have both produced handbooks essentially to this. So I'm not going to talk about that. I'm going to talk about engagement, who should engage and how they can do it. And I'm not going to go into this in any detail. So if you want to talk about it later, I'll be glad to do that. Broadly, I think typically you want the tribunals and the courts and the people who work at them to focus primarily on trying cases. That's their core mission, that's their core expertise, and that's the core job duties of many involved in the court. As we heard from the gentleman from the ICC Office of the Prosecutor earlier this morning, the ICC doesn't want to engage in building domestic systems. But there are some exceptions, of course, when you have people working in hybrid contexts, then you have direct interaction as part of the regular job duties of the court. Obviously, the courts have to engage in order to have cooperation and so on. But in terms of building domestic systems, I would argue we don't want the ICC and other tribunals to focus on that. We want them to produce useful things that other people can leverage. Useful decisions, useful rules of law, useful precedents, useful pressure. Typically, I think we want international rule of law development actors to play the primary international role in engaging with the domestic system. And this is something that we've been hearing about from different people all day today. We need the donors on board. That's where the resources are. That's where the expertise is. And I think that that's true. Again, Paige will talk about how we might do that. But focusing specifically on the people who actually do it, for internationals to be useful, they have to understand a lot of different components of what's going on. They have to have enough of an understanding of international criminal law and court processes to usefully contribute to fostering them. They have to do a ton of liaising and connecting and facilitating in order to effectively engage both with people on the international level and on the domestic level. And they have to understand what's happening in the local system well enough to be able to effectively propose projects, work with the national counterparts, and so on. I'm not going to talk about this at any length, but one of the key challenges to this is that the structure of rule of law and development work does not always enable this, and in fact sometimes puts up barriers to doing so. One way that this happens is that there's a real gap in information sharing on what's happening in technical assistance in institution building projects and programs. In the criminal law setting, the results of international criminal trials are made publicly available in judgments. They're circulated, they're out there, you can find them. A lot of the results of projects on institution building and technical assistance are held privately or not publicly released. And so even institutions and people working in the same country don't know what each other are working on. So that's one key challenge. Another idea that I think is important is that in domestic processes, internationals should play a secondary and supportive role rather than attempting to take control of the processes, so as to ensure domestic ownership and control, domestic accountability. In one of the earlier panels, we heard Judge Whalen talk about the importance of having a sense of ownership for continuation of the Bosnia court and how a lack of that sense was undermining the continued sustainability of the court. And then the last thing that I'll mention is that there are a lot of different mechanisms for engagement. So you can have, and you need to have several of these, you can't just have one. So as part of what you might consider the toolkit, how do you go about doing it, are a variety of mechanisms ranging from formal cooperative or joint programs, for example, for deploying technical expertise on investigations or evidence, things of that nature. Fostering transnational and local networks and communities so that there's not just formal collaboration, but also underlying trust, an ability to develop ideas about justice, demand for justice, for example, through online communities of practice. There needs to be mechanisms for careful analysis of every country situation, cooperation and coordination mechanisms, and mechanisms for ensuring access to decisions and judgments and laws, both from domestic and international levels. So I'm going to stop there. So hopefully I've provided you not only with some disaggregation, we have multiple purposes, multiple components that we need for the domestic trials to work, multiple groups and categories of people with different levels of expertise and ways of engaging, and then multiple modes of engagement and modes of making that engagement effective.
Great. Thank you, Elena, for laying that out for us. So clearly, maybe a quick follow-up or two. One, to ask first Paige and Guy if you have any amendments to offer to Elena's scheme. Does she get all of the actors, and do those categories work from your perspective?
Sorry, I didn't notice that she was visiting the categories. I thought it was pretty comprehensive.
I'm happy with the categories. You know, this should have been at the introduction of my presentation. So I agree with you. No, just wanted to say that yes, we have, in terms of actors, we have international actors, we have national actors, but between these international actors, you have those who are justice sector actors, and those are, you know, like implementers of activity, and at the same time at the national level. So yes, I agree with the regulations.
Oh, yes. Well, maybe one further follow-up. are those different actors, are the distinctions as kind of distinct, or the divisions, the categories, the silos as distinct as Elena has suggested, or do you see in practice blurring?
Yes, of course. She's creating a typology, right? It's just a tool that we can use to think about the world. It's not, reality itself. So of course there's a blurring. And then one thing that I would add, and then, sort of emphasize with this range of actors, and it's important not, even though, we've been encouraged in recent years to apply systems thinking to the way that we view problems in the real world. And this is, I guess, a system of a sort. It's a very loose system, and the issues, information sharing and information gaps across them are huge. And it's not just because they're coming to this work with different values or different goals, programmatic goals, etc. It's because literally there are mechanisms for sharing information about what they're doing.
I think perhaps that's what I'm getting at, is that I want to be careful that in creating a typology, we aren't actually reinforcing divisions that make sharing and coordinating difficult across among these different actors. And maybe a follow-up for you in that respect, Elena. You've suggested a real division of labor, it seems to me, between the international courts. Let's let them try cases, and then let's have the development actors focus on engaging with the national systems and doing the rule of law development work. And I think that makes sense. But will that, does that division of labor work in practice? You suggested let's have the international courts should be trying cases and producing things that are useful to the rest of us, right? And can they do that if they're off by themselves, focusing exclusively on that task? Or does to create something useful, does there actually need to be integration of those efforts?
Of course, there needs to be contact. And I think one of the huge challenges that the international courts have faced, that many people have talked about before, is their isolation from the domestic setting. But once you have an international court that's isolated from the domestic setting, then you need to re-engage it somehow, right? And the international court itself is only going to do so much of that. But where they should be doing it, and where I think those efforts would be most effectively placed, is in engaging with victims. This is something that came up in the last panel, with the people in the cases that they're working on, the people that have been harmed by those, the people that are involved, the region that's affected. That kind of engagement about the case, I think, is extraordinarily important. Outreach so that people know what the court is doing. But in terms of shaping a domestic system that can try cases, that's where I think that the International Criminal Court and other international courts don't have the toolkit, for one thing. It's not their primary purpose, and that's where they should be leaving that work almost entirely to the rule of law and development actors.
One step further on that. If they are leaving that to the national actors and the rule of law development folks, are there ways in which they frame the work that they do that should at least cast an eye to the national context and implications?
Yeah, absolutely. So I think that first, I think I should say, I don't think that I'm saying something that the international people working in the international criminal courts don't agree with or don't think themselves. My sense is that they want to be focused primarily on their cases. And this is based on a qualitative study that I did a few years ago, a series of interviews with people working in international courts and also in international rule of law. So we had lengthy discussions about their role, their purpose, what they felt was effective. So that's the first thing. But the second thing is that I've actually also spent quite a lot of time looking at how information is shared among different groups, among networks. How do networks form? How do more collaborative knowledge communities form? And how can you link people from different places and from different work settings and with different purposes together? That's incredibly important because that's how our ideas and our purposes and our mechanisms evolve constructively. And so I think that element, having people engaged in discussion and having people engaged in collaborative development of programs and ideas, that's incredibly important. And that's a whole separate topic, I think, from the more narrow question of how we develop effective domestic trials and what role internationals can play in that process.
Okay, we'll turn then to Paige to share her perspectives and lessons from her research focused in particular on donors and on civil society. And perhaps you can describe that research for us and tell us what insights about constructive engagement of those actors, between them and among others in this space you found.
Great. Well, let me open actually by dovetailing onto something that Elena was just talking about, which was about the creation of networks or strengthening of networks, not just civil society, but also with other types of justice actors. And one of the things that I've noted in my research looking at donors is examining the question of whether donors are actually encouraging that kind of behavior among these actors. And I think we found by and large that donors do not encourage that kind of behavior just through formal structures of the way that the funds are dispersed and given through competitive processes, that these actors are pitted in competition for funding, which is often seen as a zero-sum game. And so the incentives oftentimes are not there for these actors to collaborate. That's a separate issue. So now I'm going to go into what I intended to talk about today, which is some of the results of this research project that Betsy was talking about. About 2.5 years ago, I was commissioned by the Bureau of Democracy, Human Rights, and Labor at the State Department to look at the issue of international assistance to transitional justice globally. And one of the reasons why they were interested in this project and why I was interested in it is because over the past few decades, we have seen a shift in literally in financing of these kinds of efforts from states to the international community. And that, if you look at early efforts in Argentina, Chile, et cetera, these were, really were sort of nationally financed and also nationally owned processes. So and even South Africa to an extent, even though the Truth Commission did receive some outside funding, it was largely national. So what does it mean for these efforts? What are the consequences of the fact that, by and large, especially in lower income, post-conflict, fragile states, that these initiatives are being funded by the international community? Does that have some unintended consequences? So I think our first challenge was the fact that we actually don't know how much money is being spent on these kinds of initiatives, period. We know how much money is being spent on international courts, ad hoc, the hybrid. We know that because they have public budgets that they publish every year, and so we can count up the dollars. But for everything else in the world, we literally do not have the numbers. How much do donors spend on truth-seeking initiatives like exhumations, for example, or truth commissions, etc., documentation efforts? How much do donors spend on reparations initiatives or supporting those kinds of initiatives? How much do donors spend on vetting processes, et cetera? We just don't have the numbers, and the information is very difficult to find. And then beyond that, how is it that donors make decisions about what to fund? And that was also a black box that we didn't have much insight into. And so that was the sort of the origin of this process, because we wanted to understand, does the funding and the decision-making process reveal to us something about the way that donors conceive of these processes and what they think is unimportant versus important? So I'm going to be pulling some of those numbers that we developed into this discussion. However, I was asked to talk about constructive and non-constructive engagement between national and international accountability actors. So, again, this is focusing on donors. This is just, a small piece of the puzzle. And I want to make three. I'm gonna keep this to 3 points about donors' constructive and non-constructive engagement with accountability issues. And the first point that I want to make is that we found through our research, and I should also add that the research is based on more than 100 interviews with donors, civil society, national state actors in 5 countries: Cambodia, Bosnia and Herzegovina, Morocco, Guatemala, and Uganda. This was field research done, interviews with those people, and then also collection of financial data. So the first point, and a big point, is that Donors generally lack strategies or policies to guide their actions and decisions on these kinds of issues. And indeed, on a more fundamental level, I think as I was mentioning earlier in relation to Elena's comments, not only is there little in the way of strategy, there's little in the way of basic information within donor agencies about what they are funding. So you'll find that ministries of foreign affairs, development agencies, embassies, et cetera, have very little insight into what one another might be funding or not funding, very little historical memory about what has been done in that country in the past, and no access to what might be happening in other countries that might be relevant. You know, if you're an embassy staffer in Uganda, you have very little insight into maybe what your government might be funding in Guatemala, et cetera, even though that might be helpful to you. And these gaps have implications, not only for high-level funding decisions about very expensive institutions like courts, but with courts which may at certain points be literally starved for funds and not be able to operate for lack of funds, but also for more mundane decisions made by embassy staff, people in Ministry of Foreign Affairs, development agencies. And we found really, especially at the country level, embassy staff really struggle with knowing what to do with these issues, how to approach them strategically, what to fund. They're just not sure. And so one result of this, I think, I'd be interested in your views on this, but I do think that if you look at the money, which the money does show an overwhelming bias to funding big institutions, especially courts, but also commissions. There seems to be a donor bias to fund something finite, tangible. Here's something we can show that we did. And I understand that because donors have to justify their decisions to their stakeholders, right? But it's focus on funding institutions rather than focus on the larger goal, which is supporting a longer-term dynamic social process. And for that, it requires a bit more thinking and a more balanced approach to funding and what you need to fund, not just for the institution, but to support the effective functioning of that institution. And we've heard a lot about that today from many different people, from Claudia Paz in Guatemala, from David Tolbert. Elena was talking about it. These institutions don't stand alone. They require a lot of support before, during, and after their existence. I had an example there with Cambodia, and this is drawn from the funding. If you look at the total amount of funds that was spent on the ECCC and on civil society actors working on accountability issues from 2002 to 2012, you'll see that somewhere between 5 and 9% of all those funds went to support the ECCC. And 5 to 9% went to support civil society. The rest went to the ECCC. So more than 90% of those funds went to the ECCC. In fact, for civil society, more than half of the funds that were dispersed to a single organization, which we all are familiar with, Documentation Center of Cambodia. And I don't think that was by design. I think just nobody thought about what's the right proportion or what's the right scale to support this institution, not just the institution itself, but everything that needs to go on it, around or on it. My second point relates precisely to this issue of scale and proportion in donors' investments and wondering whether they realistically match the needs. And here I want to roll back a little bit on something I just said, which is that donors don't think about scale and proportion. I think largely they don't. I'm going to bring another example in, but before I say that, I want to say there is a recent example where I have seen a donor thinking about scale and proportion. And this has been very striking. I think we see this in Colombia, and it's been happening very recently. I'd like to mention a request for proposals that USAID actually put out in the fall of this year, which was a $55 million grant over 3 years to support the an effective truth-seeking process. And it was for things like a public communication, really a high-level and serious communications campaign around the truth-seeking effort. It was around technical support, certainly to the truth-seeking effort, but a whole range of social supports, ways to draw the public in, to educate about what was happening. It also included grants to communities for locally led reconciliation initiatives. And on a scale that I've never seen before, $55 million. These projects usually are $100,000, $500,000. They're not $55 million. And this is literally unprecedented. I mean, I really have never seen anything of this scale before. Will it work? I don't know. Would it make a difference to the outcomes for the ECCC if Cambodian civil society had been given $55 million to support outreach, et cetera? I don't know. We don't know the answer to that question. But nobody's ever tried it. So I'm glad that at least one agency somewhere is thinking about scale and proportion in these issues. What happens when you don't think about scale and proportion? I'd like to highlight the example of Sierra Leone. So if you look at the total amount of funds that were spent on formal transitional justice institutions in Sierra Leone, you have, and let's say from up to 2012, you have about $280 million altogether. You see that more than 96% of those funds were spent on the court. And you see less than 2% of those funds were spent on a reparations program for victims, and less than 2% on a truth-telling initiative. So you have out of those funds, $4.8 million supporting reparations for victims who received on average $80 apiece. Now again, this is not by anyone's design, and it's not as though there's anything wrong with supporting a court at that level. That's not the issue. It's thinking about then what is the proportionality and scale of everything else that needs to be supported for this to be a really meaningful justice process. And the fact is nobody was thinking about that question. Nobody designed it this way. It's just there wasn't anybody who was thinking about this at the time. And so this is how it ended up the way that it did. My final point concerns the fact that there are other models out there for the way that donors support this work. And in Guatemala and in Colombia right now, there are pooled donor funds to support a more kind of holistic, if you will, and multifaceted, I would say, multi-actor approach to transitional justice. So these are pooled funds that are managed by UNDP, that are backed by a strategy and backed by 5 years of funding from all the key donors, including the US government, and that is supporting a range of state and civil society initiatives, also supporting initiatives to bring together these actors, et cetera. So, I mean, it's too soon to tell whether this is, a more effective way to do it, but this is, it is evidence that donors are recognizing the problems and trying to do something to remedy them. So.
Research, it's striking given how much time we spent today talking about the important role of victims and giving voice to victims and victim participation, and then to hear the disconnect between that need that everyone has voiced here and donor priorities and focus. So that's quite useful. I think I'll turn now directly to Guy, who comes at these issues from a long experience working on the ground. I was thinking, as Elena was describing various mechanisms of engagement and coordination, she forgot to mention Deploy Shao Guy Makongo, who personifies coordination and has been very effective at situating himself and the programs that he manages between many different donors, many different actors, both national and international. And so I'm very eager to hear from you, Guy, about what the secret sauce is in that kind of effective engagement.
Thank you, Betty. I would like, just to give you a sort of picture of what I think works and what is not working in the field. But I have a very long list of both. But okay, so I think one of the problems we are having in the field with the coordination of international actors. Let us start by the level of implementation. If the question of posture. You have posture in English. I mix French and English. So, posture. It means that you have some organizations who have a lot of money. they receive millions of dollars to implement programs in the field. And instead of implementing, they spend money. They want, and this creates, what I call your paternalism. It means that you want to show to national partners that, yes, we want to support you. And we support these national partners without any, strategic approach. So you fall into paternalism, we fall into posture, and this creates conflict between organizations that are supposed to work in close collaboration to support national actors in the field. And this is the power of money, and it creates a lot of problems in the field. I think that this is something that should be resolved, and maybe I'm anticipating funders should talk to each other in the field. Big organizations, UN agencies, and even the other organizations who are in the field should be able to talk to each other, and also talk to other small organizations like our organization, yes, in the field, compared to UNDP, what they have like money, we are a small organization. So I think that we have, to talk to each other. Otherwise, we fall into this question of posture, where we spend money instead of implementing projects. And the other problem that we see in the field is, the lack of assistance sometimes based on international standards and norms. I could come back to this later, but we have also problems of wrong judgment, misunderstanding of a situation in the field. I don't want to, come back to the case of Nineveh. I don't know if you heard about Nineveh when in Goma M23 got into the town, and later on a mobile court has been organized, and I don't want to accuse you, maybe, but at a certain level, they said we are not going to support this mobile court, and the argument was that there's no possibility to appeal the decision of this court, but at the same time, we are having several women who have been like raped. We are also having a late perpetrator who could have like a life sentence there. So we have to be there, to control this. I think, sometimes I'm just like surprised, because of, lack of judgment, misunderstanding of the stakes at a certain level. I think it's absolutely important to know that, yes, in this court, for example, we should not support, but at the same time, keep in mind that their lives, en jeu. Yeah, I think that, we have to think about all this, while making our decisions. Sometimes also, assistance are not based on rule of law problems of a specific country. It means that, instead of conducting investigation, assessment, the same activities that have been developed for country X will be developed for country, A. And this will create a lot of problems in the field. And the last one, and I started with it, is the lack of coordination between international organizations. That's the main problem. I think sometimes, yes, international, especially donors, because sometimes you have donors who have their own program, they know exactly where they want to go, and for some donors, the RFA is already the program itself. So if you are not innovative, you will not have nothing to add there because the project is already written. And sometimes they will make difference between grant and contract, and it was sometimes confusing. But this said, there are also very good experiences in the field. What I've said before, I've talked about principles of work. But in the field now, you have, some actors who are working very well. They are trying to work and to bring solutions to the problem that people are having in the field. But this should be based on mutual respect and values. If you share the same values, you respect each other, it will be really easy for you to work together. And we should also, and this works a little bit, when actors refuse to create parallel system. It means that they work within the national system. For example, when we facilitate the organization of mobile court in collaboration with UNDP, with MONUSCO, with Avocats Sans Frontières, and other international partners, we facilitate the organization of mobile court within the national system. We don't create a parallel system that, will not continue after the presence of the international organization. And the other advantage that I see in the field is that we take into consideration what I call the main pillars, the piliers, the main pillars of access to justice. It means that we are working on legal framework. We are working of legal representation through, for example, legal aid clinics. So we make sure that we, first of all, understand what it means access to justice, and that we are building solutions to problems of access to justice that we identify in the community. The law studies are really important in fragile state, and this is also one of the points on we are working on. For example, within ABA, we have a program called Legal Scholarship, but with other partners, we are working on trainings. We are working on trainings. We are facilitating trainings for judicial actors, for police, for local organizations, but also we are organizing conferences and seminars. For me, this is part of legal education, because when people are educated, they have the possibility to defend their rights. They have to defend. So I think that, in the field, this is the example of Congo, several things are done between more international organizations on legal education, and that's the basis. You can have all these mobile courts, you can have legal aid clinics, but if people are not educated on legal, I think it could create a problem. And this is, one of the aspects where we are doing very well. And ABA, we have a new tech program, and we think that in a country like Congo, this is the solution, because the country is so big that new tech it's a solution. And now we started with like judicial database, and we are having several other actors who are interested by this judicial database, and we are trying to build a consortium around the judicial database. It helps for matters of accountability, but also to follow the cases in the court. We also develop the SMS case filing that facilitate relations between police officers in remote areas with the prosecutor. And special trainings, for example, on forensic, special trainings of forensic. This is also where we coordinate our efforts in the field. As UNDP is engaged on that, ABA is engaged, or several other organizations, Physicians for Human Rights, they are doing a very good job in the field, and we are working together on that. We are trying, to create a network of stakeholders, engaged in the fight against impunity, especially the fight against international crimes. And this is under the coordination of PHR concerning forensic, and we are having quite good results in the field. And the protection of victims based on ICC standards, we've improved protection of victims in the field. In the DRC law, for example, we don't have all the details in terms of protection of victims, but we are using it because the DRC is part of the Rome status. So we succeed to use it in the field, and we are using it while facilitating the organization of mobile courts in collaboration with UN agencies, with other organizations we are working with in the field. And the very last thing that we are doing very well in terms of collaboration in the field is, the task force that have been established or created. And this is under the supervision of the prosecution support cell. And this is very good because, they are coordinating all the efforts of international actors to fight against impunity in relation with international crimes. So I think this is, a very good example. So at the same time that you are having things that are not working, you also have a long list of things that are working. What we have to do is just, to continue to, and expect that at certain level, especially funders will be able to talk to each other.
Thank you very much, Guy. Some good examples there of the kinds of joint projects that connect the different actors that I think Elena was asking for. One quick follow-up, and then as I'm asking this, I'll invite folks to come to the mic and prepare to pose questions as well. But Guy, one of the things we've heard again and again today, and of course we know, and it's harder to do than know, is the importance of internationals understanding the national context, and maybe share with us your thoughts about, from the DRC, what are the mechanisms or ways in which internationals have been most effective in understanding that national context? What are the mechanisms for gaining that insight?
I think, as I said before, the first thing is to work alongside national actors. If you base your work on support to be brought to national actors, I'm sure you'll not miss your objectives. But if you put aside the context and that you have in mind what you want to implement, then you create problems to your own project that you want to develop. So I think the collaboration between national and, because we should not forget why we are in country. We are there to support national efforts. We are not there to support our own efforts. So I think that building dialogue between national efforts, consider our service as a tool to support national actors, for me, seems to be like the center of the support that we are bringing to. So instead of the questions of postures, we have to know exactly and to decide how to position ourselves near national actors. So that's what.
To pose questions to our panelists or offer your own thoughts, capping off a very rich day of discussions about engagement and international justice. Yes.
My name is Richard. I work for ABA, and I would like to ask one general question, which is directed to all panelists. This is a very critical issue that we are discussing now in terms of prosecuting international crimes. I'm working in CAR, Central African Republic, where we have been experiencing serious crimes, international crimes, and recently we had elections, and for the purpose of, let's say, peace, stabilizing the country, some of people who are accused, who are assumed to have committed crimes, were even engaged or encouraged by some international organization to be also elected like candidates for legislation, and especially to be within the new parliament. Now, in terms of collaboration, increasing that engagement between national and international, there is an ongoing initiative of setting up a special une cour spéciale pénale pour la RCA. So I don't know, special code for, yeah. And I know that international organizations are really active. What are kind of chances that we can, I don't, this is very complex. What are your comments? At the same time, we say we want to promote peace, we want to promote cohesion, and we encourage some perpetrators who are known to be part of the new parliament, and then there will be new effort to try those people. So what do you think in this complex situation, what can be the approach and what is the success we can give to those initiatives?
Okay, a complex practical question of peace and justice. Panelists?
Yeah, I have a short answer because you're implementing ABS project there. So I think, as I said before, the assistance should be based on international norms and standards. That's the first thing. When you start not to respect international norms and standards, no, you are supporting impunity. I think that we should not we should not be flexible on respect of international norms and standards. I think that's where we should start. Now, if this is it's done, I'm sure, because we should not negotiate. Even that's why I said before that we are having problems in the field because of problems of postures. Maybe because we want to have good working relation with the new president of the parliament. We want to have all the programs in the field. We want to make sure that we are well seen. Then we put aside international norms and standards. But the support that we have to bring to national governments should be based on one of those principles or those principles.
Other questions?
Okay, so my name is Laurie. I also work with the ABA. I just joined last week, actually. So, so we reference specifically to Africa. In recent years, African leaders and the AU, have criticized the ICC and for deliberately targeting, Africans and in the investigations, in the trials, and so on. So these African leaders have openly called for the exit of African countries from the ICC because of what they perceive as as they be targeted by the by the ICC. So my question to you is, do you think this stems from these leaders from the AU and so on have created hurdles to the collaboration at a local level between state actors and international actors? And finally, for Paige, I would just like to know whether, because your research when you're presenting, I think is very interesting. I would like to know whether it's publicly available, whether we can consult it and so on. Thank you.
Elena, I think the first question's.
Sure. I think it's inevitable that resistance or frustration with some aspect of the international transitional justice agenda or international initiatives in transitional countries is going to just spill over into other aspects. So in my own fieldwork in several countries where the ICC was involved, I saw that the work of the ICC and the work of other international organizations was often not clearly distinguished in people's minds. There are a lot of international organizations working on overlapping issues, often in conflicting ways. So certainly, these conflicts present obstacles not only for the International Criminal Court, I think, but also for other international actors engaged in similar enterprises. But I think that it's, that just makes it all the more important to grapple with these perceptions. So underlying that entire conflict, in part, is what we were talking about at the beginning, which is the ability of the International Criminal Court and other international criminal tribunals to effectively engage with the countries where they're conducting investigations and with the countries that are also considering similar issues. So it sort of reflects the difficulty, I think, of that process also.
Yeah, that's why I wanted to to come back to what you said before. I think ICC, what we expect from ICC is not just to provide us like good judgment once after like 3 years. Even if the decision is good, this is really interesting. But they have another mission. They have to educate people on their mission. They have to better communicate. This is, if they are not, especially in Africa, when we are from Africa, we know exactly how our head of state like to stay in power and so on. So they have to communicate. That's the first thing. To change people's perception on their mission. Because there is a big public and even international campaign against ICC in Africa. According to people, as my colleague said, this is just a tribunal against Africans. So I think that ICC has to communicate. That's one mission. But I can go, I have a list of what I think ICC should do. They are not just there to give judgment. They have an international mission to fight against impunity. So they have to train people. They have to sensitize, on international crimes and so on. So their mission is more than, provide decisions. They have to create better working relations. They even have to create decentralized relations with national justice actors, because currently they pass through government, to have. So I think that there are several things that they have to do in the field in terms of, in order to change the perception that people have on their mission.
Okay, great. We'll let Paige have the final word in response to that.
Like Elena, I've also observed how the politicization of the ICC in some of these countries can have sort of direct effects on the way, victims sort of approach these issues. And, but I haven't, it's completely anecdotal. I don't, see any trends. Is it positive? Is it negative? You hear some victims saying, this is very risky for me to talk about this. This puts me in danger. I have others saying, this is great, haul them before the ICC, very enthusiastic. So there is an effect there, but I think Jeff was talking about this in one of the panels. There's effects. Are they positive? Are they negative? I think it's unclear. I've also seen effects on the embassy level where there might be a disconnect between, for donors, staff who are really close to the ground in the embassy not wanting to engage with these issues, even though they're getting pressure, maybe from headquarters, in governments, but, to be more active on this, but the embassy will have the final say on these cases. So it definitely does have an effect. For the researchers, fundingtj.org, we have a toolkit. Thank you, State Department. So there's a toolkit with actually some practical suggestions for how to tackle some of these problems, but you can also email me. There will be a book next year.
That brings us to the end of our panel, our discussion here, and our conference. I think the takeaway from the day is that we understand a lot more than we did 20 years ago. And that's both good and bad. We understand now how difficult this is, how complicated it is, and we also understand we have much more work to do. So, Susanna, you're not off the hook. You've got another 20 years, and we wish you well.